lawyer. So this is often where I get a lot of calls about, employment issues or licensing issues. And it's as a lawyer reasonably believes to be competent. So if someone holds themselves out to be, or referring the matter to another lawyer. And again, I have a lot of criminal practitioners that will handle the criminal aspect of things, but let's say they're representing a nurse or a doctor and they send the licensing aspect or the employment portion over to me, or both. There's also Section D where you can advise in an emergency. However, I'm not sure I'd recommend that. Maybe if someone's being arrested or, issues that come up, there are leeways here. So, sorry, technical. So what does it mean? Really to get in trouble with the state bar, it's a fairly high standard, intentional, reckless, gross negligence, or repeatedly failing to competently represent your clients. And when we look at state bar cases, a single act of ordinary negligence doesn't suggest that a lawyer is unfit to practice. And there's another state bar case that says negligent legal representation, even amounting to legal malpractice, doesn't establish a competence violation. So you're thinking, well, why do I care? One of the issues is, the impact of incompetence. Even though the state bar may not find you incompetent in the end, the state bar fields a large number of complaints from clients or potential clients. Usually it's more clients about attorney competence, or really their incompetence. And that could trigger an investigation. I don't know if anyone has ever had to deal with those, but they are very scary and they're very expensive. But beyond the state bar complaints, and incompetence can lead to, of course, termination of services, loss of clients, loss of revenue, bad reputation in the legal community. I've had a few potential clients who've ended up as clients call me and complain about people, people associated in our small legal community, loss of referrals. But I think one of the big things and sort of the kiss of death can be these social media complaints, on Yelp or Facebook or LinkedIn. So these are things that you definitely want to be aware of in terms of your competence. You don't want a client coming to me or someone else saying, hey, they never advised me that there was a licensing issue here or an employment issue here. I may have pled this differently or handled it differently. So again, that's something that really should permeate through your practice. So professional licensing. I do think that this is often an overlooked area, especially considering how many people are impacted by it and how many clients are impacted by it. I do think every criminal practitioner should have this area on their radar, because it's not just attorneys and doctors, and you'll see the vast number of people who are impacted. And also think how a licensing issue can trigger an employment issue. Let's say for us, for attorneys, if we are suspended or our license is revoked, we can't practice. And it's a loss of income, it's a loss of our profession, it's a loss of our job. So those are the issues here. Of course, for criminal practitioners, first and foremost, it's representing the client, making sure they don't go to get a conviction or don't go to jail or prison. However, these corollary issues do impact how you negotiate, what type of plea, the type of crime that you plead to. And so we'll talk about kind of the who, what, where, why, how of licensing, and then get into some of the employment issues. So the who, people probably can't see this, the who in the corner, but who is affected? And I think a better question is who isn't? And California has over 50 regulatory agencies that deal with professional licensing. Hopefully Joe laughed. Did you at least laugh about the who in the corner? Good.
Yes, I did. Yeah, no, that was good. I was on mute, so you didn't hear me, but I laughed.
At least someone else did besides me. And I read an article recently that nearly 30% of all jobs require a licensure. I'm not sure that's accurate. Often I think that's probably too low. And you have to think that both state and local entities have licensing requirements. So again, if you think about attorneys, there's a state licensing entity, but there are also local entities as well. So for instance, recently I represented a firefighter who was a paramedic, and the state EMT, or it's called EMSA agency, was trying to discipline my client. And then I had a firefighter EMT who the local medical agency was also trying to discipline and take away their license. So many people are affected by this. You know, I had someone call recently with a question about licensing, something that I'd never even heard of. If you kind of look down in the middle of the screen, a respiratory therapist. I wasn't familiar with that, had to Google the board, went to it. So there's a lot of professions that you don't even realize or think about that have this licensing requirement and that are affected by arrests, or really more the criminal convictions. I think another thing to think about are future applicants. A lot of people aren't thinking about this, and this came to mind because recently an attorney had their client hire me to write a letter to the DA to try to either get a better negotiation or get the case dismissed outright, because this was a medical student and the conviction was going to impact their ability to get their license. So there were lots of issues that went through there, a lot of research that I had to do and write a letter that was really directly related to negotiations for the DA. So if you're thinking about not only higher education, but trade, vocational students, you know, these future applicants are affected by this. And if they are intent on seeking a future professional license, a conviction or the type of conviction is very important. And, you know, thinking about law school, you know, that moral turp application. And when I actually Googled law students, the first one to come up was the person on the left. And I thought, is that any law student? I was more appropriate on the right, the one with their head in their hand. But we want happy students. So think about not only current licensee holders, but also if they potentially want one in the future. So researching, you know, how do I find out, or how do I tell my client, you know, they're obviously supposed to know if they have a license, but how do they find out these issues? So there's two portals or two websites that I direct people to, and actually that I use. The California Business Portal. It lists professions featured on the DCA, which is the Department of Consumer Affairs, which holds most of the license, or a large majority of them, outside of education, you know, cannabis companies, contractors. There are a few things that aren't. But they have links to the state agencies, the boards, the bureaus, so you can go in there and look, or really direct your client there. Or the Department of Consumer Affairs. I think this is good too, to just kind of do some quick research there. You know, if you looked at the board or bureau, it goes on and on and on. You know, Cemetery and Funeral Bureau, these people are impacted as well. And when the investigative team, or, you know, other people looking at license, let's say for cemetery and funeral bureaus, they look at financial crimes. So you really have to think about what type of license does the client have, and how will this impact their profession in the future? So kind of, like I said, going through and just doing a quick look or search in here is helpful. And these are also helpful to let your client know, hey, go here, take a look, because on almost every site, they have information there about potential convictions or appeals, or what you can do to research this a little bit. So the biggest question I think clients have and attorneys have are, what criminal acts affect a current license? And for these types of state or local entities, there's really, thankfully, a lot of due process here. There's a lot of due process guarantees. Unlike employment, which we'll talk about in a little bit, it is almost always a conviction and not a mere arrest or detention. So it should be a judgment following a guilty or nolo plea or a finding of guilt, after, let's say, a trial. Arrests that don't result in a conviction, generally, there's always an exception to every rule, right? Don't trigger any agency action. However, something to be aware of if you think, well, we can get around this just by, pleading it down to a misdemeanor, your license won't be affected, or, you won't have a suspension or a revocation, it's fine. That's inaccurate. It's felonies and misdemeanors. So it's not just these serious crimes or sex crimes or violent. They certainly carry more penalties or punishment if we're looking at, whether to revoke someone's license or simply just issue them a public, reproval or probation, but it's felonies and misdemeanors. And of course, there's exceptions to every rule. So, when I get these cases, if I'm not necessarily familiar with it, for instance, like a doctor, a nurse, a lawyer, a therapist, those are a lot of the cases that I get kind of in and out. But a respiratory therapist, I'll have to go to the Business and Professions Code. I start out on their actual website looking there. And if you look at the bottom, every case and every person is different and every entity is really different. So, we have someone saying, I'm in here for using a firearm to commit a felony. And, the next guy's in saying I'm in here for using a plastic straw to drink a soft drink. I think that's probably definitely in the Bay Area, but you have to think every case is specific, every agency is specific. There's not sort of a one size fits all. And again, each agency has different rules and a different focus. I don't know if we have, I think without having an audience and people, I feel like I'm going very fast and whipping through all of this. But a lot of them really, the agencies look at the fitness for duty. Are you a problem for the public? And it's specific to the different entities. For instance, if you have an accountant, they are going to the bureau, the licensing bureau, when looking at whether to, revoke a license or suspend it, whatever kind of discipline they're looking at, they're going to weigh financial crimes more heavily, fraud or embezzlement. For an attorney, a lot of that is fraud. They look at the type of industry, the type of license, and how that crime really affects what happens, how that crime affects the professional license. Medical professionals and sex crimes are a big deal. Of course, these people are alone with clients, and actually sex crimes are a big deal for any licensure issue. You should always be aware of that. Medical professionals and crimes of violence as well. And I think the crimes of violence and the serious crimes, sort of rely, across the board on these types of issues. All right, I was just looking at questions. So it's really imperative to consider the type of crime, during plea negotiations.
Terry, sorry, Terry, just so you know, no questions have come in yet. So,
okay,
all right. But feel free, everyone, to ask questions.
Sure, yeah, anytime. I know I'm probably speeding through this. And this is not wine, it's water. So this is taken directly, this snapshot. I recently taught a class to nurses who work in prisons, so CDCR nurses and supervisors. And I do get a lot of calls from medical professionals and nurses. So they have sort of an easy to navigate website that talks about, what convictions matter. And you look at, Business and Professions Code or California Code of Regulations, and they specifically state a lot of the crimes that they are looking at or that the board is going to look at to determine, can you keep your license? Or do we need to have a public reproval? Should there be probation on your license or a suspension? So those assaultive and abusive crimes, failure to comply with mandatory reporting, we'll talk about that in a minute. theft, dishonesty, fraud. Those cases are always going to be a problem, but again, you sort of weigh how relevant it is to the professional license and any conviction subject to the registration of 290. So those sex crime issues. So again, it's important to think about the specific type of licensing and how a plea or a conviction of any kind will affect this in the future. Oh, give me a second. Okay, so what criminal acts affect an applicant? All right, I know this is a lot of information, but I talked to Joe about this. We're having a test on the end, and Anne said that we can only do, get the ethics credit if everyone does a test. No, I'm kidding. So for applicants, there is actually reform that was passed.
Under the bus, Terry. No tests.
I try. I am teasing about that. Everyone will get their ethics credit. I'm sure that's why they're all here. So there was reform passed in 2018, and it's now being enacted on July 1st, 2020. So that's part of the reason why I thought it was timely to have, this MCLE. And it's really, like some of the new reforms for employment matters, it's to open up California residents' ability to find a job, to get a job, and not have these criminal convictions just be, a blanket denial of their ability either to have gainful employment or that they can't get these professional licensures. And again, thinking about, when I say professional license, it doesn't just mean a doctor or nurse. It's, a contractor, a psych tech, which, isn't a whole lot. It could be 6 weeks and then of education, and then you take a class, but it's the regulatory body that requires it. So the long and the short of it is, there was a lot of information in, I think it's AB 2138, and a lot of changes. So it's denial of a license can't be based on a mere arrest or a detention. It's only based on a conviction. And the denial of a license is only based on convictions that happen the preceding 7 years. So often there's a 10-year cutoff. California, initially this bill, was much different, but they kind of met in the middle. So they allowed for this 7-year denial, and it has to substantially relate to the qualifications, functions, and duty of the business or profession. So this is kind of what I was talking about earlier. It has to be related. If it's an accountant who got a DUI 6 years ago, or someone who wants to be an accountant, they got a DUI 6 years ago, does that substantially relate to the qualifications, functions, and duty of the business and profession? I don't know, but I would think, and I would argue later, that it doesn't. And with AB 2138, the legislature allowed each board to create the individual criteria for what substantially relates. And that's in Business and Professions Code 481. So I don't know if they've done it or what's going to happen. With all these state bodies, they're always so behind in doing this. But it really should be, and it tries to mirror if you have a current license. Again, so it's allowing people to have the ability to work. And a conviction, especially if you've been rehabilitated or if it's, a significant time period has passed, then you should be able to get these licensures. There are, of course, with everything, exceptions to the rule. A serious felony defined in 1192.7 or certain sex crimes are sort of a blanket no, or a felony financial conviction that's directly and adversely related to fiduciary qualifications, functions, or duties of the business or profession. An accountant stealing or theft, things of that nature that you have to look at. And again, this is for an applicant, so someone who is applying. And there are always appeals that you can participate in later, again, because these local and state entities do have a lot of due process requirements and want to allow you to be able to try to get these licenses and then appeal. The denial can't be, and again, if people call you, I don't know how many people, and I'm sure a lot of the criminal practitioners do deal with the 1203 motions or certificate of rehabilitation. This is something that could impact the licensure in the future. So if we look at number 3, denial can't be based on a conviction, is it if there is a certificate of rehabilitation or made a showing of rehabilitation. So you can go before the court. Or if the case has been expunged or dismissed, and specifically the code references, all the 1203 sections. So if your client comes to you later, this is something that you may want to look at. Hey, do you want a professional license? Will this help? Can we try to get it dismissed or expunged? And again, there is an appeal process for denial. And I have worked on these types of cases before, more so for nurses, doctors, and lawyers, but these appeals are available if there is the denial of the license.
Hey, Terry.
Yes.
Ashley Bargain Quest had a question, and it is, would that be all theft crimes or only those involving fraud? So she clarifies, would a felony directly and adversely related to fiduciary qualifications include all theft-related crimes or only those involving fraud?
It could be either, and it's such a gray area. Each type of license is different. So it could be, the fraud, it could be, the fiduciary type cases, financial crimes like embezzlement. That's more directly related, again, let's say to an accountant or a CPA or someone in that profession, but each case is different. So it's important to take a look at what type of license you're dealing with, and then what you are, what the client is being convicted of or pleading to. So that's when I get a lot of those questions as well, people calling me up for that. But I think they'd be on somewhat the same level. It would be a lawyer stealing from the trust fund, but also committing fraud. I think they're on somewhat of the same level. I'm not sure if that answers the question. All right. So reporting, did it? Okay. I think a lot of people ask, well, what you don't know won't hurt you, but there are very specific reporting requirements. And this was one of the reasons that sort of kicked off my idea of, hey, I think we should have one of these MCLEs, because I had someone call me and say, I had no idea. I went through a criminal trial. I didn't plead to certain things, and now I have to report this. It was on a real estate license. I do get a lot of the real estate license calls as well. But people are required to report all convictions, again, misdemeanor and felony. So it's not just a serious felony or a sex crime. And it would apply to someone who currently holds it, or if you are an applicant, so you're applying in the future. And I've taken both of these snapshots are from the medical board. And so the information on what's on my screen is on the right, that applicants, it discusses what applicants have to report. And, if in doubt as to whether a conviction should be disclosed, it's best to disclose that. So of course, like I said, throughout, each agency has its own regulations, what has to be disclosed, and really, well, when. I think mainly what I see, it's 30 days from the conviction. However, that could be different. So again, if I'm getting this sort of an interesting licensure issue of a respiratory therapist calling me, I have to go to that individual board or call them and figure out what's happening. But for a larger entity, again, real estate, lawyers, doctors, nurses, they have these forms. So it's on the left of my screen that you report on. And one of the most important things is, I often say you shouldn't just, complete this form and send it in. I was convicted of X crime. Let's say it's fraud, or you have a crime of violence. then you want to actually submit something more thoughtful with rehabilitative or mitigating information in there. And that's often why people come to me. So we have this from the beginning. So we can fill out this form, but then attach, well, I went to AAs or I completed anger management. You know, I'm providing you with the police report because often the board or licensing entity will require that or ask for it later. But here's what's inaccurate in here. So it isn't simply just about saying, here's my record of conviction. Often it's providing more detailed information so you don't have problems down the line. So that's what I tell a lot of criminal practitioners or my clients, hey, we need to report this, but we need to do it, you know, in a thoughtful way. We need to be smart about it. So it's almost like a probation report or a sentencing report because we want to put out all that good stuff to the entity and avoid any type of problems down the road if we can avoid it in that initial review. Was there another question, Joe? I saw.
Yes, Andrea Kreider writes, would you be willing to share a redacted example of what a report with rehabilitative or mitigating information would look like for a client?
Oh, I can look through. It might be kind of difficult. But again, a lot of it would be similar to a sentencing report. You know, it talks about their background. It talks about, you know, and every case is different. If, for instance, the medical board will require the police report, then you go through and talk about that, the fact that the police report is inaccurate here. And again, what type of rehabilitative measures you've taken. If it's a DUI or a felony DUI or a third-time DUI, I went to a 60-day rehab program. I'm in AA, or I'm currently seeing a therapist and my therapist has written a letter. So it's very similar to, I think, what we do for criminal cases, providing additional information to DAs that way. But you want to provide that information.
So you don't want to get caught withholding information then?
Correct. And you don't want to not report this, because when you go for your to license renewal and you get caught, that's we'll say a crime in and of itself, and often worse if you don't report it. Then you're not only going to have the underlying act, but also why didn't you report it? And that will go heavier toward a revocation, so a complete termination of your license or a suspension. And like CalBar, these are public, so people can find these issues, online, and you don't want that. But I think in terms of me sharing a report, that would be a little difficult, and every case is different, but I can certainly assist with that. So the process and procedure, probably not quite as important, but if there is a reporting, or if the entity or the agency finds out about this, let's say they do a background check during the application process, it can go to an investigation. So, like a state bar investigation, people will review it, look at it, or it can go have that little red line straight to what we call an accusation. So there doesn't have to be an investigation. The accusation would be like a criminal complaint. Here is what we're charging you with, and here is what we intend to do. We're going to suspend you for a year. We're going to do a public reproval. We're going to revoke your license outright. But it's what we call basically a notice of intent. And then you have the opportunity to agree with it, try to negotiate, or go to an administrative appeal. Usually it's in front of the Office of Administrative Hearings, and try to fight that, especially if it's something more serious. And those obviously can be very expensive as well. So that's kind of the basics of it. And we can go from the reporting to the accusation. And I've sort of talked about this throughout, but like criminal cases, early mitigation is important. I think probably like a lot of people for DUI, if you have a BAC, hey, you haven't been charged, I know you're going to get charged, so start your AAs now, or start, losing my thoughts here too.
Driver safety school right away.
Yes, all that stuff. Or, some of the crimes of violence, I often say, get into an anger management program now, we'll talk to that. Or, some of the domestic violence cases, get into anger management. If therapy would help, start therapy now. All types of mitigation. What really applies to criminal cases is very helpful in these types of cases. There are also other things that you can do, but we don't want someone, writing an apology letter and then the DA getting a hold of that and saying, hey, you made all of these admissions and using it later. So, it's sort of a balancing act. And, of course, the most important thing is handling the criminal case first. All right. So I don't know if there were any other questions there before we hit into, employment rights.
I had a question if I could. What is the sort of the environment like at an administrative hearing? So say for instance, in criminal law court, you walk in, you kind of have the deck stacked against you, you can feel it. It's palpable. Same thing at a DUI hearing with the
right.
with the driver safety manager. What's it like at an administrative hearing?
Fairly similar. I think the employer, the agency always has a leg up. I always tell people, I was a DA before, and especially when I would deal with law enforcement, I'd say, you walk in as a DA and when you're a cop and you wear the white hat and you sit closest to the jury. When they get in trouble, I say, you're not that anymore. You're now the defendant. So the employer, the licensing entity, they have the leg up. But it's, sometimes it's hard for me to get back into criminal court or civil because it's so loosey-goosey. There's not a whole lot of rules of evidence. You can bring things in that you normally wouldn't have. Hearsay is very different, but you are often behind the 8 ball as well. There's sort of that, it's not supposed to be, but there's that presumption of guilt. And I did something to my screen and now I can't figure out what I did, but hopefully everyone can still see the PowerPoint.
I don't think we can see the PowerPoint.
You can't.
I cannot.
No,
Okay.
You might have to just, sorry, Thayan, again. You might have to just reshare. Share screen again.
I don't know how to do that.
Down at the bottom. Are you
Okay.
on, can you, there you go.
Okay.
There you go.
All right. Give me a sec.
Okay. You're back.
The magic of
Good job, Terry.
technology. Okay. All right. Those were probably the questions. So I put this in employment rights. How much do you know? And in that bubble, it's probably nothing. And you guys don't want to know anything. Employment, kind of like all this, it's, a case-to-case basis. But I think this is understanding just the big picture and some of the bigger issues and how it can affect, and help or hurt your case and help negotiations with the DA. For instance, I representing a prison guard and realized strangely that a 242, an assault, will result in, the loss of a firearm, but a 149 won't. So it's important to know all those issues and how it affects employment and how a criminal conviction affects employment. So starting off, like licensing for applicants, I think one of the biggest questions that people probably ask their attorney is, do I have to tell a potential employer, or how will a conviction impact me in the future? So I think Lindsay Price is here. She probably knows a lot more about this than me, but on January 1st in 2018, California enacted the ban the box legislation. So have you been convicted of a criminal offense? It's no longer just yes, and then people can kind of outright deny you. Again, it's allowing the ability, or people having the ability to open up jobs. So it's employers with 5 or more employees generally cannot inquire into an applicant's criminal history, so they're a conviction, before making a conditional job offer. So if I'm interviewing Joe and do I, in the interview, do I say, well, have you been convicted of a crime? I don't want you anymore. That's not the case anymore. So I'm interviewing Joe and I could say, I'm going to offer you the job, but it's conditional on a background check. And then with this legislation, you can see at the bottom of the screen, there's a lot of sort of appeals processes and things that have to occur if you are denied a job. So the long and the short of it is, I won't go through a lot of that, but you can tell clients, look, they can't ask you about this in the initial job interview. It can be asked about later, but you have the ability to, we'll say, appeal, discuss the conviction more. Have you been rehabilitated? Because California is very employee focused and friendly, so they want to allow people and convicted felons or misdemeanants to have the ability to have gainful employment. Now, the other question is, do I have to inform my current employer? And I'm going to say most of my answers for the employment aspect are going to be very lawyerly. It depends. So each employer is different. So unlike licensing, where there are a significant amount of due process requirements, employers don't have that. And unlike licensing, you may have to report a conviction and also an arrest. Again, each employer is different. Some are any police contact. So if I'm representing, law enforcement or sometimes firefighters, these public safety jobs, you may have to report any contact with law enforcement, whether it ends up in a conviction or not. Some employers only say, report me if there, or report a conviction, and some are silent. And then those people are lucky, they don't have to report anything. And what I always do when I'm representing a client, I look to their collective bargaining agreement. For instance, if they're in a union or a public employee, or their MOU, or if they're a private employee, I say, get me your internal handbook, get me, your rules, your policy manual, and we'll go from there to see, number one, if you even have to report this, or if it's an arrest, or you have to report the conviction. So that's one big issue. Another thing to think about, reporting the criminal acts. If you go tell your client, hey, you need to report this to your employer, well, if it's pre-conviction, what are they going to say? And then can that be used against them in the future? Of course, there are self-incrimination issues. So if they do have to report this, you want to think about, how detailed the report should be. Should they have a representative? How quickly to report? So those things, again, if it's a mere arrest as opposed to a conviction, that's something that you want to be aware of.
So Terry, I was looking in the question and answer boxes. We have several questions in there.
Okay.
So administrative suspensions, DMV suspensions related to alcohol and drugs can affect, and some will in fact affect licenses. That's an FYI. So, and it doesn't, I don't know who it's from.
Okay.
It says an anonymous attendee. Administrative suspensions, i.e. DMV suspension related to alcohol and drugs can affect, and in some cases will in fact affect licenses. So, Karen Johnson, do you know if AB 2138 has any relevance or application to CACI, Child Abuse Central Index? The CACI does affect job applicants.
It should. If it's related to applicants and their professional license, then it should. So if they have to get a professional license, then yes. Starting July 1st of this year, there are changes. So again, it's only the conviction, it's only the preceding 7 years. But there's a lot of, like a lot of these new laws, it can be a bit convoluted and difficult. So that's the basics, but there are some exceptions. There are exceptions to anything.
Okay, so Rachel has a question. Can you be sure to address the role of CDSS and other regulatory agencies that don't issue licenses directly, but can prevent employment in regulated facilities or other similar contexts, especially since CDSS regs restrictions can be based on conduct, not just conviction?
And CDSS is, what am I missing? Sorry. Joe, do you know what that is?
Do you know what CDSS is?
I do not know what CDSS
Okay.
is.
Okay,
Good,
let me
at
find Rachel. Hold on. Let me find Rachel and get her up and unmute her. Let's see how we do this here. Rachel.
I am going to talk about,
CDSS. Rachel,
Hi, sorry, this is Rachel. I think I accidentally said CDSS, which is but the social services
Right.
agency. So for anyone who is working in a medical field or childcare field, even if you can get your license back, what I have found is that people are much more restricted from working based on CDSS exclusionary orders that will often bar them for life, even if they can get their license back with much less problem.
Yes, and that's the employment aspect, and I was going to talk about that briefly because they can look at the underlying conduct.
Yeah, okay, great, thank you.
Yeah.
thanks, Rachel.
Thank you. So I think another big question probably, that we field is, can I get in trouble or fired for a conviction or an arrest? And again, the answer is it depends. For a conviction, there's nothing in the law that prevents it. Excuse me, it doesn't mean that you are going to be, going to lose your license or going to, sorry, we're in the employment section, going to get fired. But for an arrest only, it depends. The law does limit the ability for an employer to look at or discipline you or terminate you on just a simple arrest. So hopefully, Rachel, this answers some questions, or we're sort of getting there. So under Labor Code 432.7, so again, if people say, can I get in trouble or fired for an arrest or a conviction? This is really dealing more with just a mere arrest or a conviction. An employer cannot use to determine a condition of employment any record of an arrest or detention that did not result in a conviction, any record for referral or participation in diversion, and it's pre and post-trial pre-trial diversion, any conviction dismissed or ordered sealed. So again, those 12.3 or expungement, and any juvenile conviction. And a condition of employment is hiring, promotion, termination, and they're specifically for contractor issues, apprentice program, or other training program. So for instance, I had a firefighter who was terminated. He was arrested for fighting, but never charged. Now, I used this as a Labor Code 432.7 to say, well, he never should have been terminated. And I'll talk about this in a moment, and sort of going toward Rachel's issue, that there are exceptions to this. But I should note, I guess at the bottom, there's significant liability built in for a violation. And I have had success in sort of suing an employer and settlements because employers have violated this. They have terminated employees just based on an arrest only. You've been arrested, we're terminating you. But like Rachel said, if we go to the next slide, there are exceptions to every rule. So the firefighter that I was talking about earlier, where I brought up 432.7, they also used the underlying conduct. So an employer can, this is built directly in 432.7, an employer can inquire about an arrest while out on bail or pending trial, so they can ask questions about it. Peace officers, of course, are exempt from this because of the special nature of their job. And I'd say also investigations into the underlying conduct. So an employer can't say, I'm terminating you based solely on an arrest, but if they have the police report or do an investigation, a workplace investigation, then they can say, we didn't like the underlying conduct. You got in a fight. People knew you were a firefighter. You caused, bad, injured your reputation, our reputation. You said, racist remarks. So the underlying conduct, like Rachel was talking about, especially if you're going to be dealing with children or, in the medical profession can inhibit you and can, prevent you from continuing your employment. So practical considerations for arrests only: if someone's not going to be filed, get the NCF from the DA. I say this all the time. We provide that, in the employment context. Hey, this was an arrest, so you can't now terminate the person or discipline them. And if they don't, then they're in compliant with 432.7. But another thing to look at is informing the client that an investigation into the underlying conduct might happen, even if it's just an arrest. So this is something to think about. And even if you take nothing else away from this about workplace investigations, they're very frequent, I'd say, in the public arena, not as much in private, but they certainly happen, or especially in larger companies. I've had a lot, from PayPal, Google, those types of larger corporations where I've represented people. Is there a question? Or no? Okay, I saw you.
There is a question. It's, Nathan Dondi asks, does a disclosed conviction, arrest, or criminal history after a job offer have to relate to the duties of a job applied for in order for the potential employer to deny employment based on criminal history?
No, unlike licensing, there's no requirement. Unless there's a contract or some contractual basis for it. Again, like looking at, if you're a public employer, looking at your collective bargaining agreement or your MOU, or sometimes if people, a lot of executives maybe are hired for a year and they have, certain morality clauses or things of that nature. But generally you're an at-will employee, and you can be hired or fired for any reason. You can, leave for any reason. So the exception is 432.7, the arrest. So they can't make conditions of a job solely contingent on the arrest. But again, they can look at the underlying conduct, but it doesn't necessarily have to relate to the job. So let's say, it's not a condition of employment to drive, you get even a misdemeanor DUI, we don't like that. So for that conviction, they can get rid of you. I think that hopefully answers the question. It is different from licensing. So workplace investigations, again, they can investigate a conviction or the underlying facts of an arrest or police conduct. It's not a requirement. I get so many people saying, yeah, but they never did an investigation. They don't have to. They don't have to. And there is a difference between public and private employers. More often than not, it's the public employers that do these workplace investigations, like I was saying. And again, I can't stress this enough. There is no right to remain silent in these. This is not the criminal arena. There's no Fifth Amendment rights here. So if your work says, well, come in tomorrow, we're going to do a workplace investigation, you say, no, I am under criminal investigation, or I've been charged, but the criminal case is moving through the Superior Court, so I don't have to say anything. Well, then you could be they could be terminated for insubordination. So there's no right to remain silent in the employment context. And that's, day in and day out, sort of my bread and butter is representing people in these administrative investigations, whether it's for licensing or employment matters. So we have such a fine line, especially if I'm handling the licensing, employment, and criminal of, do we provide a statement, or do I advise my client to resign? So again, it's imperative to remember that there's no right to remain silent in these employment and administrative contexts. But again, you can have a representative. So if someone is called in to have an interview or a workplace investigation interview, I always recommend that they have an attorney with them, or at least talk to someone beforehand. The appeal process or settlement, again, kind of like licensure, this is probably not as important, and it differs for private employees versus public employees. Private employees are generally at will unless there's some contract that they have, an executive agreement or something, and there's no right to an appeal. There's nothing built in the labor code. I always generally, any type of private employee I get, we review the handbook or their internal rules and regulations. For instance, I had a client with Johnson & Johnson, and they allowed an arbitration that we went through, a mediation first and then an arbitration. Public employees, it's different. There are guaranteed constitutional due process rights. And there is a pre-disciplinary hearing called a Skelly hearing, and there's some type of administrative appeal that's generally required, whether it's in front of, the Board of Supervisors, an arbitration, something of that nature. I think I saw.
Correct. Ashley Bargain Quest asks, how often do you see law enforcement use information provided in the employer investigation?
I think it really depends. Not as often as one would think. There's certain confidentiality requirements, but the DA or law enforcement can get these internal investigations, so it happens. I would say for a private employer, the internal investigations happen less if it's based on a crime. They often will just try to put people on paid administrative leave and get rid of them, but it certainly happens, and they can try to subpoena the personnel file, kind of like a PITCHIS motion. So it is very important to know, will law enforcement have access to this? Can they have access to it? What's the client going to say? Will it impact it at all? Because of course, once you say that, you're stuck with it.
Got another question, excuse me, from Jesse Gill. While an employer may look at the underlying conduct related to an arrest, how about looking into underlying conduct in juvenile dependency case, which is confidential in nature? How does an adverse finding on a juvenile dependency petition potentially affect a job in general, or other jobs, affect a job in general for jobs other than education, foster care placement, etc.?
I am not entirely sure of the answer. I am not a juvenile practitioner, but from my understanding and experience, most things in juvenile court are confidential and can't be used later except for those serious and violent felonies. I don't know, Joe, if you have more experience with that.
I don't do too much juvenile. Caution is always, the main thing in a criminal case. I think I always advise my clients, their parents, anybody involved in a criminal case, look, criminal law takes priority over everything. So if you have to lose your job, you're going to lose your job. I'm going to refer you to Miss Leone, but not your family law case, not your job, not an administrative proceeding. Nothing takes place. Nothing takes precedence over the criminal case.
Right, and that's how I always advise my clients too. Look, my job is to keep you, if I have cases like this, the criminal and crossover, I'm going to keep you out of jail, I'm going to keep you out of prison, but to be aware of these other issues. From the perspective of an employer using a juvenile contest or adjudication, I don't think they are permitted to. I think the Welfare and Institution Code maintains confidentiality of those matters, but unfortunately, I'm not entirely sure. That's one area where I'm a little fuzzy, and my apologies.
So the kind of follow-up was, how about an adverse finding in juvenile dependency as to licensure, duty to disclose? So same.
Yeah, same type of thing. I think it'd probably be found more in the Welfare and Institutions Code. I think some of those, the more serious felonies may be public. I'm representing a crime victim now who she was a juvenile when she was raped, and the rapist was a minor. So there are some things about that conviction, or I don't even know if it's called a conviction. I don't practice a whole lot of juvenile, that are public and we can release, but most of it is not. So I think a lot of it would be found in the Welfare and Institutions Code related to all the juvenile matters. But in terms of employment, again, like licensure, like criminal cases, early mitigation. So they tried to make me go to rehab, and they probably should go to rehab, right? Don't be Amy Winehouse and not go. In my employment context, I can't tell you how many times I've saved someone's job by having them go to AA or having them go to rehab, you know, taking an unpaid leave of absence, go to rehab or go to therapy and providing that later. But like Joe said, and I guess you know, everything I'm saying, of course, is contingent upon this shouldn't affect the criminal case in a negative way, because the most important thing is the criminal representation. But if you can issue spot, well, what might save someone's job? What might save their license? Or can we plead to another crime? Or, you know, the early mitigation, you know, that helps criminal cases will also help licensure and employment. Just issue spotting and things to be aware of. But of course, the, you know, highest precedent here are the criminal cases. Another thing that I thought, you know, would be helpful here for people who represent the victims and witnesses of crime, sort of Marcy's Law, which I do, you know, a fair amount of, under Labor Code 230 and 230.1, and I have an asterisk there I'll explain in a minute. Generally, an employment can't discharge, so terminate, discriminate, or retaliate against an employee who's the victim of a crime and they're taking time to appear in court, who's the victim of domestic violence, sexual assault, or stalking. These are the only three. I'm not sure why it hasn't you know, expanded to elder abuse or some of the other areas like human trafficking. I see in the future that it will be expanding, but for taking time off to obtain a TRO or other injunctive relief for their own health, safety, and welfare, or the health, safety, and welfare of their child, or who's the victim of domestic violence, sexual assault, or stalking. And this is the caveat. This is only employers with 25 or more. And again, I don't know why they've separated this, but people can't be discharged, discriminated against, or retaliated against for if they're the victim of domestic violence, sexual assault, or stalking, for taking time off to get medical attention related to those crimes, obtain domestic violence services, go to a shelter, a rape crisis clinic, obtain psychological counseling related to the crime, participate in safety planning, or things related to that. And both of these labor codes, 230 and 230.1, have significant liability built in, including it can be a misdemeanor. And I've had a few clients. I had one client who reported a rape to her employer and was fired the next day. So that was a settlement that we got for that client. So it's something to be aware of, especially if, you know, you have victims or witnesses of crime and they come to you and say, hey, my employer is being difficult with me. You can turn to these labor codes. There's a lot of protections for people, but generally it's the victim of crime taking time off in court, or victim of domestic violence, sexual assault, or stalking. And I think this is a bit unrelated. I think, you know, if you are a criminal attorney, you might be the only access that people have to attorneys. So every day I'm fielding questions on COVID. This is probably not going to help, you know, if people look at this in the future, but Family First, Coronavirus Response Act, health and safety concerns. I represent a small business who there were issues with them taking the temperature of all of their employees. You know, termination and separation agreements, you know, are people being discriminated against? So their age discrimination and remote working issues. So these issues are constantly coming up. I think, like, you know, like dealing with the court system, they change every day. So if you or people you know have questions about that, you know, feel free to give me a call or shoot me an email, because they are, they're evolving and they're, you know, very new and very different issues. Again, I don't think this is something that necessarily impacts the criminal section, but because of the time we're in and we're doing a webinar because of all of this rather than in person, I thought I'd throw that out there. So last thing, best practices. You know, we don't want to have you be found guilty of anything, as opposed to we don't want your client either. I think, you know, beyond this being an ethics class, so you're getting your MCLE ethics, you know, you should care about these issues because so many people are in fact impacted. People, well, the better clients who are employed and pay have jobs or the licensing issues. Different crimes affect different types of licensure and employment. The reporting requirements, not only to licensing agencies, but to your employer, that can be a very public investigation that can result in the loss of license, loss of profession, loss of money. Early mitigation is highly advantageous, not only for the criminal aspect of things, but maybe adding one more thing in there could help with the licensing. And you want to be competent. Of course, we don't want to forget about that. So I think sort of for best practice, thinking about this again for criminal practitioners, if you have an intake form, add professional licensing to your intake form, not only for current people who have that professional license, but do you want to get one in the future? Know some of the different types of crimes that might impact the licensing. Again, thinking of, do I want to plead to a 242 or a 149? Those are issues that you should be thinking about. Discuss the job duties and job requirements with your clients for a plea. Again, this could help by, if we just shift the plea to a different crime, that might help. Advising clients, a lot of this is on an intake form. Hey, if you have a conviction, you have a professional license, you're going to have that duty to report. Or advising them, if there is a conviction, you may have a duty to report to your employer. If there's an internal investigation, do not tell your client that they have the right to remain silent, and nothing will happen because of that. Also, again, I think this is probably fairly well built in for criminal practitioners, but thinking about that early mitigation. What can we do to obtain the best possible result? But it doesn't just apply in the criminal arena, but can assist across the board. And then, bringing in what we talked about from the beginning, that competence requirement, just seeking professional guidance or referring the matter outside if you don't want to handle this. Things, again, for best practices. So those are my thoughts, having dealt with, being a criminal prosecutor, criminal defense attorney, handling licensing issues and employment. Hopefully it was, not too deep of a dive, and now you can all be superheroes for your clients wearing your cape. So I don't know if there are any other questions, or Joe, if you had anything, that you thought of. Oh, I see a couple. Whoops.
Yeah, we had a lot of compliments, actually. No more questions. I think I'll echo the sentiment from everybody. This is really informative. And again, I'm coming from a criminal defense background, and this is always mysterious to us, when clients ask about what about my employment and this and that. And really, what I do is I refer them out to outside counsel, and that's why I'm so happy that you are kind of here and available for us all.
Sure, and I think it does help with someone having, the background in criminal law too. So I understand those issues. Or if someone is handling the criminal case, then I can talk to them and say, hey, this is an issue, or move forward on a plea on this, or just answering a couple questions. I'm always happy to do that, and have worked with a lot of criminal practitioners. And I think, Anne, we are going to be able to send out the PowerPoint at some point, right?
Yes.
Great.
Yes, I will be able to send out the PowerPoint and the attendance certificate, but you all have to do one thing for me. Most of you have registered on the CCCBA website, and that's kind of what I use as my guide to who gets materials, and then the Zoom registration and the amount of time you've spent on the call, I get a report, and that dictates to me that
Who
you
actually
get
sat in.
an attendance certificate. So if you would please make sure that you at least at this point, you clearly have been on the call, so you've registered on Zoom. But if you could go back in, if you haven't registered in CCCBA website, that would be awesome. And if you're, I just want to thank Terry for doing this, and Joe for getting Terry to do this, and for you guys for putting this together and for making the effort to make it a Zoom program as opposed to a live program. I think this is going to be a little bit of a new reality for us going forward. So thank you all for
Yeah, thanks everyone. This
participating. And
definitely feels strange, but maybe the next time it will be in person if we ever get out of this.
are there any more questions? Anything
Great.
else, Terry? Great. Thank
Yeah,
you all so
if
much.
people have individual questions, feel free to shoot me an email or give me a call. It's not a problem.
Thank you all. Have a great weekend.
Thank you.
Thank you, Terry, very much.
Thanks, Joe.
Thank you, Ann.
Bye-bye.
I don't know how to stop.
I got it.
Okay.